Hello everyone, I am Monalisha Padhi. I am a legal intern at LEXIS and Company and I am a third year student of Bharati Vidyapith New Law College, Pune. And today's topic is a brief introduction on designs. Section 2, Clause D of Designs Act 2000 means features of shape, configuration, pattern, ornament, or composition of lines or colors applied to any article. The application of shape, configuration, etc. to an article should be by an industrial process or means. In the finished article, it should appeal to and be judged solely by the eye. It does not include any trademark or property mark on any artistic work as defined under the Copyright Act 1957. However, the Act under Section 4 specifically prohibits registration of a design which is not new or original or has been disclosed to the public of India or in any other country by publication in tangible form or by use in any other way prior to the filing date or is not significantly distinguishable from known designs or compromises or contains scandalous or obscene matter. The simple test for a design is the visual appeal of a design. While designs may be in a hundred, of which may some attract us, some may appear awkward and gawky. When it appeals to the eye, it generally tends to appeal to our finer senses. There must exist a visual appeal too. So, how a cancellation of registration is done? Section 19 of the Designs Act 2000 provides that any person may present a petition for the cancellation of registration or at any time after the registration of design to the control on the ground that the design has been previously registered in India or that it has been published in India or any other country prior to the date of registration, or that the design is not a new or original design, or that the design is not registrable under the Act, or that it is not a design as defined under Section 2, Clause D of the Act. So, what is a piracy of a registered design? A piracy of a design means that application of a design or its imitation to any article which has been previously registered for the purpose of sale or importation without taking the written consent from the registered proprietor. Publishing such copied articles or exposing terms for sale with knowledge of the unauthorized application of the design to them also involves piracy of the designs. What remedies are available in case of groundless threats? According to Section 23 of the Designs Act 2000, in case of groundless threats to a registered proprietor of design, the provisions of the Patent Act 1970 shall apply. The reliefs that are available are first, a declaration to the effect that the threats are unjustifiable. Second, an injunction against continuance of threats. And third, such damages, if any, he has sustained thereby. Some of the landmark cases on design law are: first is Gopal Class Works Limited versus Control of Patents and Design 2006 Supreme Court. In this case, it was observed that in order to destroy the novelty of a design registration, prior disclosure, whether by publication or by use or by any other way, must be of the pattern, shape, and/or configuration applied to the same article. It was further observed that when the novelty of an article is tested against the prior published document, the main factor which is required to be judged is the visual effect and appeal of the picture illustration. Further, the court held that such visual effect and appeal of the pattern or configuration must be considered in respect of the article in which it is applied. One more landmark judgment is Faber Castle Asting Shellsap versus Shallow Pens Limited 2015 Bombay High Court. In this case, it pretended that of design infringement and an action for passing off, wherein Cello had copied the design of crayons of Faber-Castell. It was observed that the court must have due regard to the overall impact of the rival marks or goods, and that the law recognized the importance of the shape in which a trader chooses to sell his goods. Firstly, the test is whether the shape adopted by the plaintiffs is capricious meant purely to give the article a distinctive appearance and characteristic of that particular manufacturer's good. Secondly, a concise imitation by a defendant of the various constituent elements that go into the uniqueness of the plaintiff's product must lead to a conclusion that confusion and deception are both respectively inevitable and intended. That's all for the topic. Thank you. Please like and comment on the video and subscribe the channel. Thank you.